meeting mode. So thank you, Natalie. Natalie Johnson Abbott is our administrative specialist and is helping me tonight. I'm Kelly Henderson with Formed Families Forward, and we're going to hear from Valerie Leroux very, very soon. She is the star of this show tonight. So we will get moving, but I do want to remind you we are in meeting mode. So please do mute yourself. You're welcome to be on camera or off camera. That's completely your call. Please do use the chat box as you have questions. Valerie is kindly going to set aside time to address questions. So definitely chat those in, and Natalie and I will try to help sort those, as we do expect a pretty large group. So do not hesitate to ask your questions in the chat box. I'm going to go ahead and get moving. Just so we have as much time for Valerie as possible. If you're not familiar with Formed Families Forward, we're so thrilled that you are here. Very briefly, we're a nonprofit organization in Northern Virginia. We are a family-led nonprofit, so we are all family members formed through foster care, adoption, and kinship care, or raising children with specialized needs and disabilities, mental health conditions. And we serve Northern Virginia foster, adoptive, and kinship families who often are raising children with specialized needs, disabilities, mental health concerns. We do our work through offering free trainings like this one, consultations to families. That would be a one-on-one scenario where we would be glad to meet with you in person or by Zoom and sort of do some problem solving, whatever the circumstances. A lot of those are around special education and navigating school systems and school challenges. But we are glad to talk with any foster adoptive kinship family who could use that support. We have a lot of resources on our website and on our social media pages, so I encourage you to check that out. And if you are here live tonight, we are recording this, but if you're here live tonight on August 13th, please, and you would like a certificate of attendance, please email Natalie, and she's going to put her email in our chat so you can contact her, but contact her after the fact and she will double check attendance, and then she will get you a certificate of attendance. Just a couple things that Formed Families Forward has coming up very soon this fall. We have a back to school webinar next Wednesday. Again, same time, 7 to 8, very quick in and out, starting the school year strong. And this is, again, focused on foster, adoptive, and kinship families and some of the strategies, tips, and things to consider. We have a great webinar coming up using the work of Robin Goebel, if that is someone who you are familiar with, on changing tough behaviors. And Melissa Lublin, our family support and outreach coordinator, is going to be giving that one, and that it may be an introduction to some future work that we will be doing on Robin Goebel's work around really addressing a brain-based approach to addressing challenging behaviors. And then early October, we have a great session on communicating effectively with those in your family, as well as those outside your family with whom you may be trying to collaborate. We also have a fabulous new opportunity that we were just able to secure from the Department of Behavioral Health and Developmental Services. Some wonderful new trainings with a clinical psychologist, Dr. Kale Sednick, who will be presenting a training in person in Fairfax on the 9th of September, and this says Woodbridge, but it's actually Manassas location on the 23rd of September, and then a virtual session. And just really wonderful, very specific tips and tricks, and actually some takeaways that you can take home to find some good strategies as you enter the school year with your children to ensure safety, regulation, and a real nice roll into the school year easily. So again, Natalie's going to be chatting those links in so you can register. All of these things are free of charge. And for this one, we actually have a childcare stipend for those of you who might be coming in person. So we are able to provide a childcare stipend in the form of a gift card. So take a look at that. Finally, we have, in terms of training, we have some online courses, and that window for fall and winter is just opened up in our Learning Your Way online classes. Those are go at your own pace. You can earn certificates of completion. They're interactive. You can pick your topic. You can take as much time as you want. So just just lots of good information, and new course actually coming online, and that is positive parenting, as well as obviously all these listed there on the right. Again, Natalie will be chatting that link in. And finally, we do have an array of peer support group offerings. We not listed here, but we do have a youth and young adult support group that's going to be starting on Tuesday nights this fall, and those are weekly for 8 weeks. And then we have for you all, maybe here in the audience, parents and caregivers, we have a Fairfax Kinship support group that meets once virtually and once in person each month. And we have a Formed Families Together support group that's for foster, adoptive, and kinship families. Again, also once virtually and once in person on different evenings. So we have a lot of support group options for you. We know that peer support is a critical tool for some of us to just make it through the challenges and the ups and the downs that we have as we parent the kiddos in our lives. And we're going to get back to session evaluation before we let you go for the night. We will return to that. And I'm going to stop sharing and turn it over to Valerie, who I think will give you a little bit of sense of her and all that she brings to us tonight. Valerie is with the Virginia Poverty Law Center, and we are just thrilled and so appreciative of your time. Valerie, take it away.
So much, Kelly. And thanks, Natalie, for helping get everything set up. And thank you all for being here, and also for all that you're doing for the children who are in your care. I know this is, can be really challenging, and I know you do it because you love your family and love these children, but that doesn't necessarily make it easier to navigate their needs, your needs, all the various systems that you have to try to navigate and get in order to get the services you need and the support that you need financially and otherwise to help raise these children. We all know that it takes a village to raise a child, and hopefully the Formed Families Forward is helping be part of your village to help you guys as you are caring for these kids. So I'm going to try to share my screen here and see if we can all see the slides. And I think it's going to work. All right, and I'm going to try to put that. The other day I had a hard time getting it to go into what do they call it, slideshow mode or whatever. So I'm going to hope that it works today. From the beginning. Oh, there it is. Can everybody see that? Wonderful, it worked. So my name is Valerie LaRue. I'm an attorney with the Center for Family Advocacy at the Virginia Poverty Law Center. And we're an organization that works to try to make changes in the way Virginia serves families and people of middle and low income in Virginia. And so we look for policies that aren't working for people and figure out how to make them work better. And we've been working on issues around kinship caregivers for many years. For instance, we've worked on the KinGap bills that have passed in Virginia, which took a very long time. We've worked on some of the bills that were passed this year that we'll talk about today. And then we also try to help kinship caregivers when they run into stumbling blocks that shouldn't be stumbling blocks. For instance, getting TANF for their relative children that they're already entitled to. And also help give them advice and support as they might seek certain legal recourse and things like that. So we also have some helplines. We have a senior legal helpline. If you go to vplc.org, you can find our helplines. And so you're always welcome to call our helpline and get advice and support on other legal issues that go beyond kinship caregiving as well. So sometimes people are facing something like recently somebody contacted us because they were having trouble with a predatory loan, for example. So these are the kinds of things that might not necessarily have anything to do with your kinship caregiver role, but nonetheless can impact your kinship caregiver role. So whether we are able to help you through the helpline or can refer you to the legal aid office in Fairfax, please do reach out, and hopefully we can give you some options. So we do advocacy in the General Assembly and also with agencies. We attend meetings that the Virginia Department of Social Services have as they're discussing how to change policy or set up guidelines. We also do educate attorneys across Virginia on these issues so that they know what's going on and what they should be doing. And then as needed, we do litigation. That's not really the biggest part of what we do. In fact, it's a very small part of what we do, but we do sometimes do impact litigation. So for instance, we've sued the Virginia Employment Commission because they weren't timely processing people's applications for unemployment when they got laid off during the pandemic and things like that. So we just try to work on things that hopefully help make low-income Virginians' lives easier. So the title of this is Addressing Common Concerns for Kinship Caregivers. So I'm going to talk about the things that I have seen in my years of helping kinship caregivers. And then please do put in the chat any questions that you have that come up, whether they're related to things that I say or questions you already have. And we'll address those at the end. So I'm just going to get started. So the Department of Social Services has a legal duty to support family integrity, and that means keeping families together. And that includes reasonable effort to prevent removal of a child from their parent or their guardian. And that's a federal law. It's also state law. So what they're supposed to do is if there's a reason why CPS has gotten called about a child, they're supposed to work with that family and provide supports that might be, for instance, financial supports. Like, let's say the reason why CPS has been called is because the parent doesn't have childcare, and so the child is sometimes being left alone. Those are the kinds of things where the department is supposed to step in and say, okay, we don't want to remove your child because we want to keep a family together. And so we're going to provide some supports here, maybe parenting classes, maybe connecting you to childcare supports. And that applies to both a child and a guardian. So if you, as the child's kinship caregiver, are struggling, they're supposed to help you stay together as well. If the department determines that the child cannot safely remain at home with their parent or guardian, then what the department is supposed to do is they're supposed to find, consider, and approve relatives as caretakers. And there's two different ways that could happen. So one is through what's sometimes known as alternative living arrangements or safety plans or kinship diversion. But basically what they do is they go to the grandparent or other family member and say, can you take this child to come live with you? And we've asked the parent to sign this paper saying that they understand that the child's going to come live with you, and nobody ever goes to court. So that's one way. The other way is to approve the relative as a foster caregiver. Now, the difference is, as some of you probably know, is if you are a licensed foster care provider, then you are going to get the full foster care maintenance payment when the child lives with you. Whereas through these alternative living arrangements or safety plans or diversion or whatever it's being called where you live, that is not an automatic thing. You do have the right to apply for certain kinds of financial supports, but it's not necessarily the same as getting that full foster care maintenance payment. Now, maybe that's okay with you because maybe you'd rather not deal with all the issues that come when the child is in foster care, because then you have to, have your, life really put under a microscope. And maybe your child came to live with you a different way. For instance, this is an informal arrangement that you worked out with the child's parent yourself. So there's different ways, but the department is supposed to have what they're calling now a kin first culture. They're supposed to first look for relatives that can that the child can live with, and they're supposed to determine what is the best, this alternative living arrangement or foster care. Now, this year on July 1st, a new law went into effect. In the past, if somebody wants to become a foster caregiver and be a licensed foster custodian, they have to have a criminal background check. And under Virginia law, there's a whole list of crimes that if somebody was convicted of, there's a certain number of years that crime must have been in the past in order for them to be approved. And then there's some crimes that you can never be approved. But Virginia has had, a lot of other states have a sort of a two-tiered system, so that if you are a relative, the rules are not as stringent for you as they are for a stranger, which of course makes sense. Because obviously just because you were convicted of a crime 10 years ago doesn't necessarily mean that you're going to be a bad caretaker now. But if you're a total stranger to a child, then the state needs to be more careful before giving somebody's child to a stranger. But Virginia did not until this year, despite many efforts to try and change the law, to have a different system for relatives. This year, that law finally went into effect just last month, July 1st. And what it does is it requires the department to come up with its own processes for approving relatives if they have a certain crime on their record, instead of just a blanket process that they do with all people who apply to become foster parents. So that's something new. If you apply to be a foster parent and you are denied, a few years ago, we got a law passed that requires the department to tell you why you were denied being licensed as a foster parent and gives you a right to appeal that denial. So for instance, I worked with a family who was denied, and the letter that she got from the department just said, oh, we think you were divorced too recently and your life isn't stable enough. And I was like, what? I was divorced and I had my child live with me. If being unstable because you're divorced is a reason not to have your child, then I guess my child should have been taken away. That's ridiculous. So when they have some other reason and then they give some silly reason like that, then the person now has the right to appeal that denial. Now we've already talked about the barrier crimes. And then it's also important to know that if the case has gone to court, so if you are a foster caregiver of a relative child, the court has to continuously consider every stage when it goes back to court if the child should still be in foster care or should go home. And the department, of course, is responsible for providing, again, reasonable efforts that we saw in number 1 up there to reunite the child with their family. So this year, a new law went into effect, and I don't think this law is really going to impact any of you, but it goes back to number 3, the alternative living arrangement, safety plans, kinship diversion. Now, as of July 1st, again, when departments do that, when they enter into such an arrangement with the parent for the child to go live with a relative, they now have a lot of rules that they were supposed to follow before, but not all departments did. And so now this new law, hopefully, will make it so that all departments are following that. So one thing that they are supposed to do is only have the child go live with the relative for 90 days. During those 90 days, they are supposed to provide services to the parent to get their child home. They're supposed to provide services to the relative for financial support and other support for caring for the child. And they're supposed to provide any services that the child needs. So if the child has, needs help with their IEP or anything like that, the department is supposed to provide all of those things to support the family and reunite them within 90 days. Now, if 90 days come and go and they are still, the parent hasn't corrected the things that brought the child to CPS attention and to this resolution, then the department has another 90 days to try and help the parent get themselves together so that the child can come home. If at the end of that 90 days, the second 90 days, they still haven't been able to determine that the child would be safe if returned home, then they have to go to court and seek a court order of removal. So I'm guessing that most of you, the children came into your care before that law went into effect on July 1st of this year. But that law, is different from what was happening before. Now, it's been the case since 2022. And I'm going to switch to the next slide. And I'm going to skip around a little bit. Oh, I don't know why I have 1, 2, 3, 1. Sorry about that. I think I deleted something and on the slide and it went to 1. But anyway, I'm going to go to 3. And that is the financial support for relatives when a child is in their custody. So since 2022, the Department of Social Services has had funds to provide what is called the relative maintenance payment. And what that is, it's a $200 bump per child for a child in relative care to the TANF that the relative can already apply for. Now, TANF is not, there's federal and state rules around TANF, and that's temporary assistance for needy families. But the kind of TANF that most relatives will qualify for is often known as child-only TANF or payee TANF. And this is so important because if you are not getting the foster care maintenance payment and you are applying for TANF, because it's not super common, a lot of eligibility workers are not even aware of the child-only TANF or the payee TANF. And so the relative will come in and say, I'm applying for TANF, and the eligibility worker will say, okay, how much money do you make, blah, blah, blah. And then they'll say, well, you make too much money, you don't qualify for TANF. That is not the standard for child-only or payee TANF. If you make too much money to qualify, if you make enough money to qualify for TANF, great, because then you'll get more money. But if you don't make enough money to qualify for TANF, it doesn't matter, because you should still get the TANF payment based on the child's income, not your income, because you are not getting that money. The child is getting that money. And that is a real distinction that a lot of eligibility workers don't understand. So in the packet of materials that, that Natalie will give you a link to, there is a page from the Virginia TANF manual that the eligibility workers have, but they don't necessarily, it's a very complicated manual. I wouldn't want to read it if I worked for the Department of Social Services, but it's the page that explains the TANF, child only or payee TANF, and how the person is eligible. So you might think, well, how does a child have an income? Well, children can have income. So most typically, that income would be child support that the child's payment is paying to you for the care of the child. Or it could be maybe the child gets SSI, either for a disability that they have, or maybe coming from their parent. So that's typically the income that children have, but they might have other income. So that is what the department looks at, the child's income, not your income. And so that sheet, I have had a lot of families come to me and say, well, I can't get TANF because, I went and they said I made too much money. And I said, well, that's not the standard. Take this page back with you and go back there. And then people have gotten TANF. Now, if you are getting TANF, if you're eligible for TANF, and in order to be eligible for TANF, you have to be an actual relative by blood or marriage. So, we've seen families where a grandmother is taking care of children, but she's not actually a grandmother to the children by blood or marriage. So maybe she lived with the grandfather for decades, and everyone in the family considers her the grandmother because the grandfather and she bought a house together, lived together, shared everything. In this case, the grandfather had died. The children had been living with the grandfather and the grandmother. But because they weren't married, she was not considered a relative by blood or marriage. And so when the grandfather died, she was no longer eligible for that TANF. So, those are the kinds of problems that can arise, hopefully not for any of you, but they can arise. If the child came to live with you because the Department of Social Services was involved in transferring that living arrangement from the parent to you, then you are supposed to get the relative maintenance payment or bump. So it just about doubles the amount of money that you would get through TANF. So that, I'm sure some of you are going to have questions about that. The other thing that comes up with TANF is the cooperation with the Division of Child Support Enforcement. And that's a really sticking point. It should not arise in those cases where the CPS got involved with the family, because after all, they know who the family is. It arises in those cases that are informal arrangements between the parent and the grandparent or a relative, where the department says, well, we want to collect child support from the parent to offset the money that we're giving you. And so you need to cooperate with us and give us the name and address of, the child's parent, which may be your child. And a lot of relatives don't want to do that for a number of reasons. One is that maybe they know that their child is really struggling to get on their feet, and to have child support, deducted from their paycheck is not going to help them get back on their feet. Instead, it's going to make it harder for them. Another reason why a lot of times relatives don't want to do this is that they want, this is their child, and or their family member, and what they want is for the child to have, go back to the actual parent. After all, if you're an older person, you may not want to be raising a whole another generation of children permanently. You may hope that the parent becomes able to take the child back. And you don't want to blow up the relationship between you and your child, or your child and their children. And that's another reason that a lot of people do not apply for TANF, because they're worried about that aspect. Like I said, if the children came to live with you through CPS intervention, then that should not be an issue. If it isn't, there are some exceptions. And if this is a concern for you, I would mention that. I would say, one of the exceptions is if you're afraid of the parent. Well, that's not a great exception, but another exception should be that you don't want to, you want the child to go back home, and you don't want to blow up that relationship, and you don't want to make it so that the parent can't, for instance, put a rent deposit down and things like that. So talk to the eligibility worker about that. If you don't cooperate, what they're supposed to do is dock the amount of TANF that you receive. So you should receive some TANF, but not as much as if you didn't. So it's a penalty, basically. Now, a lot of people have children who are living with them who are of school age, and they want to enroll them in school, and maybe the parent didn't live in that school district, and so they want to enroll them in the school district where they live. And if you're in Fairfax, I know that that can be really difficult. Fairfax is very much a gatekeeper for enrolling children in the school. And so they're supposed to, the law says that if a child is living with a relative, permanently or temporarily, then because the parent is, permanently or temporarily unable to care for them, they're supposed to let the child attend that school. And there was another law that changed this year to create more stability for children. So if a child is put in foster care, they're supposed to be able to stay in that school so that they don't have to change schools at the same time they're being disrupted in the rest of their lives. So the new law extends that to kinship care, and also when a child is, for instance, exiting foster care and exiting kinship care. So I'm not exactly sure how this is going to be interpreted, but hopefully what it would mean is if the child is living with you and is enrolled in Fairfax County schools, and in the middle of the school year, the parent says, okay, I've got an apartment, etc., blah, 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 child can come home with me, but I'm in Arlington, that the child doesn't have to be uprooted from their classroom and re-enrolled in Arlington Public Schools, but can finish out the school year in Fairfax. Some schools are requiring a power of attorney or an affidavit from the parents to prove that in fact the child is really living with the relative. So your mileage may vary as far as what your school district requires. Doctors may also require a power of attorney if you go to take the child to get medical care, or if you want to get the educational records from the child, things like that. Getting a power of attorney done is really pretty easy. I don't know if that's something that Form Family Forward helps you with, but it's basically just a form that the parent signs saying, I'm, person X, relative, has my permission to approve, to enroll my child in school, approve medical care, etc. That's not required for accessing public schools. You just need to prove that the child is living with you and relying on that. Now, sometimes people want to get legal custody of the children. And one of the documents that will be in that tranche of documents is a fact sheet on how to go about applying for custody. One thing to know about custody is that there's two different kinds of custody. So there's physical custody and legal custody. So physical custody is who does the child live with? And typically a custody order will say, okay, child lives with person X, and then person Y has visitation or parenting time. The court can choose to call it either one. And, that visitation could be supervised visitation. It could just be regular visitation. There's a lot of, restrictions that a court can decide to put on the visitation. There can be joint custody where the child lives with one person this many days and the other person that many days. There's a lot of different ways that physical custody can go. The other thing is legal custody. So legal custody doesn't have to do with who the child lives with. It has to do with who can make legal decisions for the child. And those legal decisions can include things like medical care, or what school the child is enrolled in, or what kind of school the child goes to, or what church the child goes to. So those are all things that a person with legal custody has a right to make decisions on with the other person, even if they don't have physical custody. So, for instance, when I was divorced, I had physical custody of my son, but my ex-husband had shared legal custody with me. And so if I, wanted to send my child to a different school, or something like that, I would have to go to him and say, hey, look, this is what I'm thinking of. This is why, blah, blah, blah. And then we would have to work it out. So if you are considering filing for custody of your relative child, that is an option for you. You can have shared physical custody, shared legal custody. And the good thing about that, from my perspective, is that makes it easier for the child to return to the parent in the future. Because, for instance, if you both have custody, if you both have physical custody, then the child could live with you half the time and with the other parent half the, or with their parent half the time. Or if they have legal custody, even if they don't have physical custody, at least they're able to make decisions with you about the child, which can make the child feel better, can make them feel better, and can be sort of a good shared parenting all around. So just consider that if a parent loses physical custody of their child, it can be really difficult to get the child back. So Virginia presumes the child's parent is the right person to have custody of the child. But if someone else gains custody of the child, then they lose that presumption. And now they're just like a relative filing for custody. They have to prove why it should be the child should come back with them. So just something to consider, that keeping that door open could be a really good thing for the child, especially if you become unable to care for the child as you get older. So we already talked about child-only TANF and the child maintenance payment. There's also child support. There's for infants. There's WIC. There are child care stipends. There's SNAP, supplemental nutrition assistance program, and famous Medicaid. So based on your income, the the child may be eligible for some of these things like Medicaid, FAMOUS, which are state supported medical health care assistance. And that can be really valuable if you are, for instance, on Medicare and are not able to put the child on your health insurance, or if you don't have the health insurance or can't afford to add the child to your care. So that's another thing you would go to the Department of Social Services for. If you are confused about what the options are, you again can call our senior legal helpline and they can help you figure those things out. SNAP is something that, again, you might not qualify for SNAP if you don't have the children living with you, but it's very possible if you do have the children living with you that you would qualify. So that's a good thing to apply for. And childcare stipends if the children are young and need childcare because they're not able to go to school yet. Child support is sort of a tricky thing because a lot of relatives have told me, well, the child didn't qualify for TANF because the amount of child support that I receive for the child is high enough that it's, since it's considered income, I either got no TANF or a very small amount of TANF. But here's the problem. The parent only pays me the child support every other month or every 3 or 4 months, or maybe they pay me half of it this month and another half next month. And so I can't rely on it as a source of support. And that is really tough. That is something to maybe work on with the Division of Child Support Enforcement to help get them involved so that they can try to make sure that you are getting, the child is getting the child support that they deserve and that you need to help care for the child. Or just go to them and ask, that you get TANF and then they collect the child support rather than you having to worry about how much money you're getting this month, whether you're going to be able to afford to buy food for the child. We've already gone through this, and that is the child only TANF, payee TANF. Another source of financial support is the Children's Services Act. Virginia state that has a Children's Services Act, and it's commonly called CSA. And what those funds are special funds to provide services to children with mental health issues. And so the child has to have certain emotional, mental health, behavioral health needs that are not being met through another source. Typically, in order to get funding from through CSA, there has to be some kind of governmental involvement, maybe DSS involvement, court involvement, maybe the child is in special education, they receive Medicare or some others, but there is possible to self-refer. Typically, the CSA office is going to be part of your local Department of Social Services. And how it works basically is that if you ask or apply, the FAPT or Family Assessment and Planning team looks at what the child's needs are, looks at all the possible sources of funding to cover those needs, and then decides what they will pay for. And then every locality also has a CPMT, that's a Community Policy and Assessment Management team. They're responsible for all the programs, making sure that they meet all the local CSA policies as well as the state mandates. I think there are some very few localities that do not access CSA, and the reason why is because CSA is a local match program. And so some localities don't want to put up their own funds. And so they choose not to draw down the CSA funds to help families, but I don't think that's a problem where you all are. So another issue that arises for kinship caregivers is help with parenting. So, if you may be a relative caregiver who has never raised a child, or if you're a grandparent or a great grandparent, maybe you raised your own children decades ago. You're not familiar with what's available out there for children, or what the sort of rules are for children, or how to deal with challenging behaviors. I saw you're going to have a webinar on how to deal with challenging behaviors. But that's another thing that relatives sometimes find really challenging. So it sounds like Form Family Forward can really help you all with that. Parenting classes, information about child development and behavior. Another thing might be homework. You know, if you haven't done homework in 50 years, how are you going to help your grandchild do the homework? You don't even know what kind of math they're teaching now. Is it new math, old math? What on earth is going on here? And so finding help with that, whether it's tutors for the child to help them with the homework if you're not able to, or brushing up on your own skills. That's another thing that you might need help with. And then the physical labor involved in raising children, that's as you get older, you know, that's not insignificant. Hopefully Form Family Forward can connect you with supports through like area agencies on aging, to help with those kinds of things. I mean, just getting that car seat into the back seat can wear you out. As I mentioned earlier, with shared custody arrangements, if you're worried about your health and your continued ability to care for the child, having a shared custody arrangement with the child's parent or with another relative, that could really help ease that concern. So if something happened to you, you know, the other relative is already on the custody order. Another option is what's called standby guardianship. And that's something you need to really get a lawyer to help you with. Again, it can be through a legal aid or something like that, or it might be something that the Form Families Forward can help you with. So standby guardianship is a special kind of guardianship whereby you designate someone to become the guardian in the event that something happens to you. But you can't do it just ordinarily. Like you can't say, gee, you know, I'm older, I might, you know, who knows, I might, you know, have a heart attack and die or fall and break my hip or whatever. You have to be in the situation already. So if you've gone to your doctor and the doctor says, oh, you need to have, you know, open heart surgery or something like that, that's when you would go about doing the paperwork for the standby guardianship, because we all know anytime you have surgery, there's a possibility you won't come out of it. So the standby guardianship basically says, if something happens to me, if I don't wake up after surgery, if I, you know, have cancer and it's very possible that I won't survive this round of healthcare treatments or chemotherapy or whatever, or during the time that I'm having the chemotherapy, there's no way for me to physically care for the child because I'm too sick. That's when standby guardianship would come into play. So that's not the same as custody. It's supposed to be temporary. So that, you know, if you're temporarily incapacitated or if something serious were to happen and you were to die, this other person would step in. Now, let's say you do die and the other person steps in under the standby guardianship. And of course, they have to agree to this. You can't just say, I think this so-and-so would be a great person. They have to agree to it. So they have to sign the paperwork. You can't just have this sudden child show up on their doorstep because you filled out the paperwork. But what happens then is then the court has the opportunity to decide, should that person keep the child going forward permanently until the child's an adult? Is there someone better that, you know, should take custody of the child? Is this person actually a suitable person to raise the child? So then the court gets involved if the child, you know, if in fact you are no longer you're totally out of the picture. So that's something to consider if you're concerned about your health or any declining health or physical issues. And then again, our senior legal helpline is a good referral source for issues that you may be facing, even if it's not related to the child. For instance, somebody emailed me today about a situation where they had a predatory loan. In other words, a loan where the interest rate was just so high that it was making it impossible for them to support the child in their care and pay off their car loan. So, you know, it could be something like that. It could be a housing issue. You know, if you're facing eviction or anything like that, if you want some advice about the standby guardianship and information, go ahead and call our senior legal helpline for advice on that. So we still have time left for questions, so I'm going to stop talking and I'll stop sharing my screen. And I see there's about 28 things in the chat.
Yes.
Natalie, were you going to read the questions, or Kelly?
I'll give a first effort, and Natalie can chase me down and make sure that I've covered everything. So let's, I'm going to try to group them a little bit. You talked a lot about TANF and the supports, and there were a couple clarifications. I think you've already addressed one of them, but let me ask another one. If TANF goes to the parents for support, how is the support amount determined? Is it by income scale, or if it goes before a judge, can the judge decide on a higher amount, which then the parent would really have difficulty paying? The scale I saw seems reasonable, but if a judge can make it higher, that's what I'm afraid of for the parents. So basically, yeah, you get the question.
So the TANF amount wouldn't change. So the TANF amount is a set amount. And it can be based on, for instance, I think right now there's there used to be 3 levels, and I think there's now 2 levels. So it's based on locality. If you're in Fairfax, you're probably in the higher locality base, because it's based on cost of living. So there used to be 3 different levels of amount. And now I think there's just 2, and I'm assuming that Fairfax is the highest level, and I think that's around $200. And so if the parent is paying you child support already for the child, then the amount of TANF you would get would be, you would get less, because they would deduct the amount that you're already giving for the child. So they would say, okay, the child gets $200 a month, and you already get $100 a month from child support from the parent, so we're going to give you $100 a month. So that's how that works. And yes, if you went to get more child support, or the Department of, or the Division of Child Support Enforcement said, oh, you're making more money now, so you should be paying more under the child support guidelines, you should be paying $125 a month, then they would deduct another $25 a month from the TANF. So that's how that works. So it's not that the judge changes the TANF amount, it's that the judge only has jurisdiction over child support. And so that's how that would work.
Thanks. We have another question about close relative adoption, which I don't think you really talked about. So can you discuss close relative adoption? A child in a home more than 2 years. Is TPR, or termination of parental rights, or a home study required? Do they need to be licensed? And there was a question that just said, the question included, especially in the Tidewater Regional Court. So maybe this is something that is a little more regional, or is happening perhaps in that area more frequently. I will let you take it from here.
Yeah. So with a close relative adoption, different from, a stranger adoption, there's a bunch of steps that you're able to skip over. And so that makes it take less time and be more sort of streamlined. And so one of those things might be that if the child's already been living with you for, 5 years or whatever, the judge might say, oh, I'm not going to order the Department of Social Services to do a home study because, you're already living here, or I'm not going to bother appointing a guardian ad litem, or whatever it is. So basically it's the same as any other option, except that it can be more streamlined and happen faster because you're not a stranger. The judge doesn't have to make you jump through so many hoops in order to adopt your relative child. And if the parent agrees, so that's another thing. So either if the parent has already been, their rights have already been terminated, then that's not an issue. But let's say the parent's rights haven't been terminated yet, then, again, the parent can agree to allow the child to be adopted and give up their rights versus, having to go through the whole trial to have their rights terminated. And of course, even if the child was, in the custody of the Department of Social Services, the parent always has the right to, say, I know that I'm not going to be able to take my child back. And so rather than having to keep jump through these hoops in order to get my child returned to me, I'm going to do a voluntary entrustment to the department. And I do want my child to be adopted by, my mother or my aunt or, my sister or whatever, whoever it is. So that's also a possibility. Typically, unless the Department of Social Services was involved, typically you would have to get an attorney to help you with that process. But again, it would be less expensive because it's going to be a shorter process.
Thanks, Valerie. There's a question, again, lots of folks are contributing really important thoughts and experiences, and I'm trying to just identify those questions first, the questions that have been posed as questions first, and not invalidating anybody's experience, but I do want to try to address those who actually posed questions. I also want to mention, I know that some of you may have to jump out as bedtime approaches. Natalie's going to put our session evaluation link in the chat. So we do appreciate you taking just a moment to fill that out so we know what other topics might be of interest to you. There was a question about the standby guardianship. Can the non-relative current caregiver be made the standby guardian, or does it have to be a relative?
No, it could be anybody. So, it could be your best friend, could be a neighbor who likes your child, could be the child's teacher, anybody who's willing to step into that role should something happen to you.
There's, I think, some general, like I said, a lot of commentary in the chat. But I think the general one question that sort of covers that is, why is there such a difference between kinship care, I assume informal kinship care, and foster care? That doesn't seem fair. So I'm not sure you have an answer to that, Valerie, but if you want to give a little perspective on that.
It's really not fair. I think that's really, it's not fair. And that was one of the reasons why we worked on the bill a couple of years ago to allow relatives to appeal when they were denied the ability to become foster parents. And then the bill this year that passed to address those barrier crimes, the things that keep you from becoming a foster parent. It's not fair if the state says, well, it's fine for this child to go live with you, even though you have a conviction for, I don't know, using drugs when you were 20 years old. If the child just comes and lives with you now, but we are not going to pay you a foster care maintenance payment, we're not going to approve you as a foster parent, even though, what is the difference? The child's living with you. The only difference is you're not getting paid fairly to do that. And so that's why we worked so hard on that bill. So it isn't fair. My feeling is Virginia has about half, or, at any given time, Virginia has about 5,000 children in foster care. It is because of bad or lack of, record keeping. We don't really know how many children have been diverted from foster care to kinship care, but estimates are that it could be the same amount, 5,000, or even more, maybe even twice as many. Hopefully, Virginia has a terrible child welfare information system. Hopefully, they have gotten money from the General Assembly to upgrade that system. It's going to take a couple years. Hopefully, they will do that and they will start collecting that data and we'll be able to see. To my mind, the state is abdicating its responsibility to these children and to their relative by not, discouraging relatives from becoming foster care custodians, and instead saying, oh, you must take this child. And I know that relatives have been told sometimes by the agency, well, if you don't take this child, we're not going to consider you for foster care. I don't know how common that is, but more than one relative has told me that. And I think that is really, that's coercive and it's really terrible. It's not fair to the child, it's not fair to the parent, and it's not fair to the relative. Now, hopefully with the TANF and with the TANF, relative maintenance payment, TANF bump, that, and then the burden that is put on the department to basically do all the same things that they're supposed to be doing if the child is in foster care, that some of the departments might say, gosh, we have to do just the same amount of work if the child is in this program as if they were in foster care. So what's the point? and they will stop doing it. In my view, a lot of these departments have basically said, oh, the child was unsafe with mom. And so we took the child to go live with grandma, and now we're closing the case, we're done. And that's abdicating their responsibility. And hopefully this bill will help stop that.
So Valerie, I'm going to ask you 3 more questions. We have about 4 minutes left. So if you can be really succinct with your answers if possible. And then again, at any time, if you in the audience, the participants have questions, we are glad to relay those to Valerie. She, I think, kindly has agreed to have her information shared. So, but one of those questions actually is about what your organization does. So can you talk about whether your organization has free lawyers who can help with custody?
So we don't. We are kind of like the policy arm of the legal aids in Virginia. So if you qualify, you can get free legal help from Legal Services of Northern Virginia through their Fairfax office, but we wouldn't be able to represent you in those cases.
Thank you. There was a question, I think, akin to what we were talking about a little bit earlier about what benefits in terms of post-secondary. Is it true that kids in foster families get college tuition benefits in the state of Virginia through programs like ETV, tuition grants, Great Expectations? And if so, why are those benefits not available to children in informal kinship families?
Yeah, that's another thing that I think is really unfair about that dual system that we have. There are some, I think that you should still talk to, for instance, children who are without parental care, so they're with a relative. When they fill out the FAFSA, they can fill it out and say that they're without parental care so that the parent income is not considered when they're deciding how much financial aid the child should get. So that's a good thing to know. They might have to provide some like a affidavit to explain why they're not living with their parent, but the parent's income would not be counted against them.
Thank you. Yeah, there has been some clarification on the FAFSA, which has been, I think, helpful. And then we're just going to take one last one because I do think there's a little confusion in the state of Virginia about the term guardianship. So I'm going to read the question as it is. Are there any efforts to provide better guidance when pushing a child to kinship guardianship is appropriate as a permanency rather than adoption? Guardianship seems to be automatic when kinship is involved, but sometimes it may be better to do a TPR. Is there a resource to help kinship families?
So, that's a really good question, and it's kind of complicated. When Virginia first adopted the KinGAP program, the Kinship Guardian Assistance Program, it only applied in certain circumstances. So how the federal program works, and that's because we were drawing down federal money to cover some of this cost. The child had to be it had to be in such a situation where the child was actually living with the relative as a foster parent, and there was a reason why the child couldn't be adopted. Sometimes that reason might be that the court said, well, I don't think the state met the standard for me to terminate the parent's rights, so I'm not going to terminate them. Another time it might be that the child, aged 14 or older, said, I don't want my parents' rights to be terminated. I don't want to be adopted. So at age 14, assuming the child is competent, they have a right to not to veto basically that adoption. So so there's federal program, only a small number of children qualified. The state funded program, because so few kids qualified under that program, the state determined that more children could leave foster care to guardianship, so it would actually be cheaper to actually pay that same KinGAP payment to a relative, even if the child didn't meet all those federal standards. In this case, the child doesn't have to be in foster care as long and doesn't have to have been in foster care with the relative. So there's still restrictions, but not as much. So, it's so fact specific for each family as to whether KinGAP is better or adoption is better. It's really up to the department, the judge, you, the parent. There's so many different variables there.
Yep. Lots. And I think, thank you, Valerie, for making the distinction, because I think we hear about KinGAP, and depending on the local DSS, it means different things. So thank you for that clarification. Our time is up. I know there's a lot of passion around this and a lot of really unique and challenging circumstances in many families. And I encourage you, if you are in the well, actually, if you're anywhere and would like to join us virtually for our Kinship or our Formed Families Together peer support group, please look into that. We would welcome you. If you're local, we do have both of those groups meet in person once a month. So definitely take advantage. And I think that these are the topics that come up as they should as families navigate. Valerie, I want to give you just a second to say anything else that you might have come to mind as you are wrapping up.
I just wanted to repeat that I'm always happy to answer people's questions if they reach out to me. I know this is really complicated stuff, so just feel free to do that.
Thank you. I am going to just remind folks that we do have all of the handouts that Valerie's kindly given us, and we will have the recording of this session on our website at the address that is in the chat. And we do really appreciate the feedback from in our session evaluation. So please do take a moment to complete that. Natalie will be sending out a reminder and a thank you to everybody. Again, if you need a certificate of attendance, those requests go to Natalie. And we wish you well. And thank you so much, Valerie, for sharing your expertise with us. Good night, everyone.